Why did you do this? And I think sometimes understanding why we do certain things will help us not repeat it. If it's
Asking the court to give Mr. Montoya that opportunity.
Zero 8168 State versus Nathan Tyler Montoya. Can I have parties announced for the record for the state? Defense.
David Andre
Quiet,
Woodard
please,
for
we're on the record.
David Andre Woodard for Mr. Montoya.
And are you Mr. Montoya?
Yes, Your Honor.
All right, you entered a plea to the lesser included offense of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you applied for deferred adjudication. According to your plea bargaining agreement, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,500 fine. The state is opposed to your applications. This will run concurrent with County Court Cause number 734433. There should be Chapter 62 registration and no contact with the complainant. Have both parties had a chance to review the TAP evaluation and PSI report, state?
Yes, Your Honor.
Defense?
I have, Judge.
Any objections to the TAP evaluation or PSI, state?
Not this, Judge.
Defense?
No, Your Honor.
All right, state, you are opposed. Do you have any witnesses?
We do not, Your Honor. In lieu of the witness, we do have a letter from one of the witnesses, will enter it in as State's Exhibit A. I believe there's no objections.
No objections, Judge.
We'll reserve our argument.
All right, then the court will accept into evidence State's Exhibit A if both parties will give me a chance to review it. All right, if you'll give that to the court reporter.
Yes.
Thank you. And if you could, I think it's marked on the inside as State's Exhibit, correct?
It is.
All right, defense, do you have any witnesses?
No, Your Honor. Only argument.
All right, then the court will hear argument. State, you are opposed?
We are opposed, Your Honor, but we'll reserve.
All right, defense.
First off, Judge, looking at the PSI on page 2, this is Mr. Montoya's first interaction with.
Just one moment. Excuse me, counsel. If you, Ron, if you all could just move to the other end. Hi, if you could just move to the other end, we're on the record. No problem. You're our counsel. All right, we're back on the record. And counsel, what page did you say?
I'm on page 2, Judge, of the PSI regarding Mr. Montoya's criminal history.
Yes.
The only criminal history that he has, Judge, is this current case and also the misdemeanor case that's going to run concurrently with this case. Aside from that, he has no prior criminal history. He's 30 years old. At the time of the incident, he was employed at Amazon. He was working. This case was resolved fairly quickly, Judge. Mr. Montoya accepted responsibility fairly quickly. He took a plea, and now we're here before the court. Since he's been in custody, I believe since May of 2024, he's had no contact with his brother, who drafted the letter, I think that was State's Exhibit number A, and he's also had no contact with him. Speaking with him, he realizes what he did was not only wrong and inappropriate, but it was also a criminal offense. Also, there's a TAP evaluation that is the last page of the PSI report, and the TAP evaluation does not show that Mr. Montoya has any substance abuse issues or any alcohol related issues. We are asking the court to grant his application for deferred. I know it's a difficult case, of course, to consider granting a person deferred adjudication. We're asking the court to give Mr. Montoya that opportunity, one, because he has been in custody. He's had time to reflect and to think about what he did, not only what he did, but the repercussions that happened with his niece. Looking at the PSI and also the letter that the state submitted, does look like the need through some mental health trauma. She likely would still continue to experience, but she has been doing well in school. There will be no other contact with Mr. Montoya and we're just asking the court to consider his application for deferred adjudication. If the court does not consider that application, I believe the plea bargain was for a cap of 7 years. We're asking the court to possibly consider a downward departure and placing him in TDC for a lower amount of sentence opposed to the 7 years.
All right, is there anything you wish to say?
I do accept responsibility for my actions.
All right, just 1 second. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God? That's it.
Yes.
All right, you can lower your hand, state your name for the record.
Nathan Montoya.
All right, so is why? Why did you do this? And the reason why I asked that question, because that's a part of, I think, an introspection, right, to yourself. So why? And I think sometimes understanding why we do certain things will help us not repeat it if it should not be repeated. So why?
Why? I believe I do need more self-reflection to understand as to why it was something that should have never been have done. Going through my own depressive episodes and self-loathing, I would say I have caused myself to go down a spiral of deep creativity, I believe.
Mhm.
However, I am able to bounce back up and to truly self-actualize myself. As to why, or that it may be because I'm also myself the victim itself, and I understand that happens because of that kind of thing. I'm still trying to come to terms as to why, basically. I don't like saying I don't know yet,
Okay.
but it is something that I do regret. I have lost something precious to me. Understand?
All right.
That's all I can say.
All right. Any questions from the state?
Not necessarily.
All right. Thank you. I appreciate your testimony. All right. This is what the court is going to do. The court is not going to grant your application. The court will find you guilty. This will run concurrent with County Court Cause Number 734433. There's to be Chapter 62 compliance. There's to be no contact with the complainant. There's a $1,500 fine, time and money run concurrent. Court will give you credit for any time served. I am unsure if the therapeutic community, if you will qualify for it. I'm going to request it for you because I think there are some mental health issues and some trauma going on with you based upon what has happened to you and based upon what I read in the PSI report that he has brothers who are in prison for the same thing. And one of the brothers was actually a perpetrator of him. And the court will sentence you to just 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not with regards to sentencing, Your Honor, we do have the benefit.
All right.
Not from the defense judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. With regards to the therapeutic community, you will still have to request that. It doesn't increase the time that you're in custody, but it can help you, I would say, deal with your past trauma. You understand? I do appreciate that you accepted responsibility for this. Sometimes people never accept responsibility. Sometimes they blame other people for their actions. Court is calling 2024 CR 5390, State of Texas versus George Laverne Hawkins. Could our parties announce for the state?
Andrew Harris, second with the state.
Defense?
Renee Munoz.
And are you Mr. Hawkins?
Yes, ma'am.
You entered a plea on June 20th, 2024 to the offense of assault of a peace officer. According to the plea bargaining agreement, punishments be assessed at 6 years in the prison. The state is silent on your application. They're taking in consideration 2023 CR 7315, 2024 CR 5389, County Court Cause number 729000. Have both parties had a chance to review the PSI report? State,
Yes, Your Honor.
defense?
Yes, Judge.
Any objections to the PSI report? State,
No, Your Honor.
defense?
No.
Have both parties had a chance to review the TAP evaluation? State,
Yes, Your Honor.
any objections?
No, Your Honor.
Defense?
Yes, Judge, and no objections.
All right, the state is silent. Defense, do you have any witnesses?
No witnesses at this time, Judge, only a clarification, explanation / argument.
All right, you may proceed.
Thank you, Your Honor. With regard to Mr. Hawkins, I've been dealing with him for some time, assisting with these legal matters. He has been keen and set on taking advantage of the specialty court because I believe that specialty courts are designed for individuals like Mr. Hawkins that are dealing with issues and they need that support and structure from a team that can help them understand their issues and put different resources in the community. We did apply for Veteran Treatment Court on May 30th. He was denied that court, albeit being a veteran and having served this country honorably and receiving honorable discharge because there is not a sufficient nexus between his issues and the service, according to the program, Judge. So after that denial of that program, we went ahead and had him considered for lifetime recovery. We did reach out and have him screened, and we do have documentation here that he does meet criteria and can go there if allowed by the court. We also reached out to felony drug court in advance to see if he would meet criteria for that program as well. I do have documentation here that he does meet criteria. However, he was denied at that time because it is obviously, the court is well aware, post-adjudication program, and we're not at that stage as of this time. So Judge, he's been dealing with some issues. He did graduate from University of Houston with an accounting degree in 2010. However, some of the issues he's dealing with, namely surrounding substance use, he uses methamphetamine, things of that nature, had led him to be homeless and have some interaction with law enforcement. The nature surrounding these offenses are not of an egregious type. He was arrested and fled out and made contact with the officer's shin, I believe. The other offense that he was charged with, Judge, he was actually at Cross Point, excuse me, and he was going to be emergency detained from there and taken to a facility. However, he was routed to the jail upon them alleging to have spit on the back of the officer's head. So there is some issues here. We don't believe that the issues are necessarily attributable to a criminal mindset, more so a cry for help, a need for treatment, Judge. So we're asking the court to consider the avenue of treatments with inpatient treatment facility. I referenced the PSI, and the PSI is recommending inpatient treatment. We're asking for that to be ordered, Judge, so he can be transferred from here to lifetime recovery, have him doing well.
But what is, this says in the report, he declined to have a mental health screening, stating he didn't want to sign for any of the department's dual diagnosis programs or residential programs because he doesn't like the idea of sitting in jail for 4 months just to go to treatment.
Yes, Judge, and if I might clarify that, I believe he's maybe had heard word around the jail that maybe the DDRF times are long. They can result in months-long waits to get him into facility. And I think that he's been in custody for a number of months now. He's wanting to get a hold on his treatment and recovery and believes that lifetime recovery would probably be less of a wait time to get him into that treatment, Judge. So I did explain that in the PSI with him, and he stated that was his concern about the mental health facility being a much longer wait and him waiting in custody until a bed opens up, where in contrast to that, the Bear County is notifying me that they do have space for him at Lifetime Recovery, and they can readily transfer him there to get him on the road to his recovery and to turn his life around. And my suggestion, I think the court hopefully is on the same mindset, that if he does that, it's going to put him in a better place to work the felony drug court program, which he meets criteria for, and give him that access to that specialty court, which we were vying for and trying to get with the Veterans Treatment Court, but he did not meet criteria for that, Judge. For these reasons, we're asking respectfully for the court to consider that. I do have the treatment documentations of been evaluating him, Judge, as well, for the court to consider, just to verify. It's my understanding, confirmed with the state of Texas representatives, that they're silent as to this request because they see the need for him to get some treatment and some help. And he's been patiently waiting for us to try to get it together to hopefully create these avenues for him. And I think we have some options and availability here, Judge, to get him some treatment over just incarceration.
All right. I see that he is a veteran and was honorably discharged.
Yes, Judge.
And it appears from reviewing the history and reviewing the instant case that there is an issue with drug use. There's an issue with mental health. Now, whether that mental health occurred due to his military service or not, the court doesn't have that information. So I'm going to give you a choice. Sometimes I can give people choices. Sometimes I can not give them choices. I always tell people, you can't choose how your recovery is going to look like in the sense of, I want this treatment, I don't want that treatment. Because if you could do that and write your own program, we wouldn't be here and you wouldn't have the criminal history that you have. So I can sentence you to 4 years in prison, or what's going to end up happening is I'm going to refer you back to felony drug court because I know they have a dual diagnosis program. If they don't accept you, you're going to SafeP. So those are your choices.
Is, Your Honor, just for clarification, the felony drug court dual diagnosis, is that within the felony drug court, like
Yes.
program? Would it still be an avenue for him to get treatment at Lifetime Recovery? If
He's going to felony, if felony drug courts accepts him, then drug court will set his conditions. If felony drug court does not accept him, he's going to SafeP.
Okay, yes, understood, Judge. If we could be considered for the felony drug court, and then whatever recommendations they may have, as long as they're reasonable, Judge, we'll definitely, he'll be on board with that.
No, I mean, felony drug court,
Yeah.
it doesn't matter if people think their recommendations are reasonable or not. It's, if he goes to felony drug court, then felony drug court is going to set his conditions. If he goes to felony drug court and he says, I don't want this, then what's going to end up happening, a motion to revoke is going to be filed.
Yes, Judge, I understand. And ultimately, we're looking for an avenue for him to get treatment through a specialty court. So that's with the recommendation of felony drug court piece. He wanted me to voice that he would like to be considered for that and take part of that program.
All right, the court is going to sentence you to 8 years deferred adjudication. Take in consideration 2023 CR 7315, 2024 CR 5389, 729,000. He's to remain in custody for the following evaluations. A referral to felony drug court. If not accepted, then SafeP, followed by aftercare, field visits, 1 time per month until further notice. And I'm sorry, instead of the anger management probation, it's going to be this a hostility management aggression control program. There's to be no contact with Kay Talley, Talley. And probation with regards to the MIC, maybe the best place for that if he's not accepted in to felony drug court. Once he's released from safety, if we do the mental health treatment through the VA. Probation, also, we'll do 200 hours of community service restitution. Probation, is there anything else he needs? I'm sorry?
No, sir.
Is there anything else you need from the court to be successful?
No, Your Honor. Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do
Understood.
you understand?
Yes, ma'am.
And the court did not see any restitution amount for the officer. So state if there is going to be restitution to the officer, you will need to provide that within 30 days.
Yes, Your Honor.
All right, is there anything else?
Nothing further, Judge. Thank you for allowing us to be heard on this matter.
All right, thank you.
The courtroom fell silent as Judge Stephanie Boyd questioned Nathan Montoya face to face, asking the one question that mattered most. Why did you do this? Instead of offering a clear explanation, he spoke about depression, self-loathing, and even suggested he saw himself as a victim. When the judge pressed him further, he finally admitted, "I don't know yet." That answer became a turning point. Although the defense requested deferred adjudication, emphasizing his clean record and willingness to accept responsibility, Judge Boyd concluded that he had not fully confronted the harm caused by his actions. Referring to the victim impact letter and the seriousness of the case, she focused on accountability and the lasting consequences of the offense before delivering her decision.